Before I was in this role, when I was Attorney General in Kansas, I was one of the original supporters of the so-called Keep 9 movement, one of the first to lend my name to it. I think we ought to ask the people of this country through the constitutional amendment process whether they want to take off the playing field the possibility of expanding the court for the purpose of stacking its membership to try to influence the outcome of its decisions as a tool for an aggrieved political party, either party, to use when at that moment in history the court's decisions are not going as that party would prefer. This discussion in this committee today is nothing new in our history. We've had these same debates since the founding. We've had them throughout our history. John Marshall has made his decision, now let him enforce it. We had this debate in the 1930s. I always get a little bit of a chuckle when people talk about kings and no kings. I mean, my goodness, we had to ask the people whether they wanted to amend the Constitution, changing the original framework, I would say to my friends on the other side. That's what the amendment process is about, in order to prevent a president at that time, who many in the public called a king, from seeking re-election yet again, 4 terms. But one thing that was rejected in the 1930s, when there was a lot of turmoil in the architecture of our system, was packing the court by expanding it. In fact, it was proposed and it was rejected by bipartisan majorities, including majorities led by members of the other party, the president's party, in both houses of Congress, because our predecessors in these roles had the wisdom to understand that fundamentally rewriting the rules of the game by expanding the court to get a preferred outcome in your cases is counter to how we should govern ourselves in this country. It's not only just not fair, it's unwise. As our witnesses testified in the subcommittee on this measure, on this topic, it has no limiting principle. If you expand from 9 to 10 to 13 today because one faction in our country wants it when a different faction is in power, what's to stop them from expanding to 15 or 20 in order to get their preferred outcome? We have settled at 9 justices for the majority of our country's history. As our friend, the ranking member, said in his exposition on the history of this issue, we've been at 9 since just after the Civil War. That's prudent. It works. Justices of both philosophies, appointed by presidents of both parties, have said 9's a good number, you ought to stay there. This proposed constitutional amendment asks the people of the United States, through the constitutional amendment process, whether they want to keep 9 as the magic number, to use the phrase of my friend on the other side. That is not only exactly what this debate is about, it's all this debate is about. All of these other discussions, grievances with the court, they may have their day. People can propose what they want. We can debate and vote. But that's not today. This is about whether or not people ought to be asked if they want our Constitution to set the size of the court at 9, to take away the temptation of politicians in the heat of the moment to stack the court with new members to get their preferred outcome on issues that are important to them. I think we ought to ask the people if that's what they want. I think we ought to advance this amendment. I want to thank you, Mr. Chairman, for bringing it forward. I urge my colleagues to support it. Let's get it on the floor. Let's get it out of the chamber. Let's get it out to the states. And let's let our people decide what they want their government to look like.